Good evening. We have a few more minutes, so everybody is here. Let's see. Early birds. 8. Yep, sounds about right. Are my presenters ready? I hear quiet.
Who are you presenting again?
Michelle is one.
Novia and Michelle. Next week,
Hi, this is Michelle.
okay, next week we'll have another crew, so don't worry. Everybody will have their chance. So let's see. I see Miller is on. Michelle is on. And Veronique is on. Yeah, man. Be good to go.
I'm not tonight, right, Ms. Archer?
Put
Am I
Benedict.
Huh?
It's tonight.
So question before people come, because I never present.
People what is on.
Everybody's on, I try to plead my case now. I never present. I don't know what to expect. So I'm gonna listen.
You just talk and we'll guide you through.
Okay, so I'm just stating what I read.
More or less.
Yes, Ms. Archer, Veronique, you're not alone, hon. Ms. Archer sent you a lovely note. Yeah, but you don't answer me back. Anyways,
Hold on, let me see this. Hold on. When you send this lovely note, because I don't remember no lovely note.
The day you sent it to say I is a presenter.
Oh yes, I saw that.
Okay, and I send you and I say, why me?
Yes, I saw that.
And then I ask you, what does that mean? What to do? Anyways, I say, must you just state the case.
State the case. That's it.
Okay. All right.
There's no need for you all to die.
Because I'm dying right about now.
I said, Jesus, I say, why me?
I'm on top of that. It's like 30 pages long. I was like, what?
But you can get the gist of what the issue is.
Yeah.
Yeah.
Okay.
You don't have to read all of it.
Okay. So it's almost just like stating the summary of the case.
Yes. That's all you do.
All right, I'll try.
Yes, nothing trial but a failure, so try.
Yeah. Okay. We leave the ruling for the class.
Which man?
Hmm?
The ruling? No, we finish it. We're gonna discuss it because everybody had it.
Okay, no problem. All right.
Read. So you really at the end discussing whether you agree, disagree, what do you learn from the case?
Okay.
How law works now. Law is just the legislation.
Okay, got you.
Right, and the judges interpret the law.
Yes.
So if you want to know what it means, you have to read the cases.
Right, I got you.
Right.
All right.
That's why I always add the cases in wherever I could find them, because it makes it easier. And I find over time students could answer questions or they understand it better. Oh, okay, that is why it is happening. I see why the abstract title was taken, the investigation was taking so long. Okay, you have to go through all of these things. So yeah, it's good to see it in black and white. So I'll give you a couple minutes and then we'll get started. I see Yvette just joined us, so.
Yes, ma'am, okay.
4, 5, 6, 7, 8, 9, 10, 11. Oh, we have more than last week. I have more people to play with last time. Let's see, I have Yvette. Neely, I don't know. Yeah, Neely was here last time. I'll catch Neely on the next go, but I had 9. So who am I?
Next go.
Yeah, next week cases.
Oh boy.
What happened?
Sure?
Yeah, I'm positive.
Okay.
Choose normally that's random.
Sorry?
It says random. My selection is random.
Oh, okay.
Yeah, but it wouldn't include the 3 who are presenting tonight.
Oh.
Yeah, because they present. It'll be someone else's time. But don't worry, everybody get a chance. No need to, scream and kick and scream and all the rest of that. You will have a wonderful opportunity to discuss. So are we ready?
Yes, just before we start, Ms. Archer, I'm sorry. I'd like to update, or do I have update my email address with you or turn to the office?
No, send an email to me and Miguel.
Okay,
Yeah,
okay,
that'll
all
work.
right. Thanks.
Okay. All right, who's gonna start first?
I guess I'll be the first mule.
Go ahead, Dan.
Okay, good night, class. My name is Michelle Forbes James, and I will be presenting on the case of Montague Investment Limited and Westminster College and Mission Baptist Church. Montague Investment Limited, in this case, is the plaintiff, and Westminster College, who is the first defendant, along with Mission Baptist Church, is the second defendant. But we need to make note that they did not participate in the church itself, that is, did not participate in this case. However, just as a nutshell, the plaintiff, Montague Investment Limited, would have bought a piece of property back in 2013. And after purchasing the property, they would have carried out a survey like a year later. And the survey showed that the defendant, that's Westminster College, was trespassing on their land by encroachment. They would have built, they would have erected a chain fence, built a wall, did some pavement to a road, and they were parking on the property. Montague Investment Limited, when they would have discovered that, they would have asked the defendants to remove themselves from the property, but they, however, refused. And Ms. Archer, you can tell me if I going down the road, the wrong road, okay?
Okay, all right.
They would have refused, and hence the suit. And so the plaintiff, that's Montague Investment, initiated an action against the defendant, the college and the church, because it made claim that the church would have purchased a piece of property to the north of Montague Investment, and they would have erected a piece of what they would have done onto Montague land. But the church would have purchased their property back in 1984, and here it is, Montague is now purchasing their property in 2013. However, the issue when brought before the court then has to now decide who is the rightful owner to this property, whether the defendant has some claims to the property as well. So the court has when the court would have looked at all of the things being presented to them, they would have awarded Montague Investment the property rights to the property, and that indeed the college was trespassing. In its investigation, two things when I would have came out that although Dr. Cooper, who is the pastor for the church and also the president or the principal for the college, the church would have purchased their property, but they did not have any rights to Westminster. So although they would have claimed that they had the rights, I suppose, to the belief what we call squatters' rights to the property. But however, the Limitations Act would have stated that you have to have been on that property without interruption. I think you said the last class, Ms. Archer.
Yeah.
Without any interruption for at least 12 or more years. However, they would have shown, well, evidence would have shown that they would have done whatever they would have done to the land in 2004. And then 2013, they would Westminster purchased it. They advised them that they were trespassing on their property in 2014. So that does not give them 12 years between 2004 and 2014, would not have given them the 12 years that they would have needed to say that they have rightful possession or squatters' rights to the property. So the court says, no, that's not your property. That is indeed Montague's property and you need to move. And the court would have said to them and to pay Montague for damages to their property because you put up the wall, the fence and did the road and was parking on the people's property.
Mhm.
Yeah,
So the court said that they couldn't claim adverse possession, correct?
yes, they could not
Right.
claim adverse possession. And I
So-
just,
Go
go ahead, Ms. Archer.
No,
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 you-
oh, let me wait for you to say it.
I just wanted to say they could not claim adverse possession because adverse possession is when someone other than the rightful owner gains the legal right to the property after occupying it without permission. And so they did not gain the legal right, having the Limitations Act put into play.
Mhm.
I wanted-
So what was, so on what grounds were they fighting this on if it wasn't adverse possession?
Well, just the fact that they were taking squatters' rights, that they had the right because they've been on the property long enough. They realized that it was not their property. Because,
Right. And because they realized it and they were encroaching on it, then
right,
it's trespassing.
right,
They were trespassing on the land.
right.
That's what they were doing. So there's a difference between trespassing
And adverse possession,
and possession.
yes.
All
But
right.
they admitted to trespassing, but they also want to think that that's theirs because of how long they've been on the land, but then they did not. Oh, one other part of it as well. They did not bring that up in the pleadings. They only did so in an affidavit.
No, they didn't.
Yeah, they didn't bring it up in the pleadings and then the court only go on the pleadings. Not so much
Yes.
the affidavit. Yeah, I saw that.
All right, very good. See how easy that was?
Thank you. I can breathe now.
Yes, you can breathe.
Thank you.
Good job, Michelle. You made that look easy.
Thank you.
Great job, Michelle. Okay, Ms. Archer.
Yes, my dear.
Okay, so I'll go next.
Yes, go ahead.
Okay, good night, class. In the matter of all those 3 adjacent pieces of parcel of tract of land containing an area surveyed by 7.712 acres, 8.229 acres, and 1.704 acres, respectively situated south of Harold Road, Western District of the New Providence. And in the matter of the petitioner, Mr. Simon F.B. Roden, under the Quieting Titles Act in 1959. Now, the case started with Mr. Roden, I think his name is Roden, petitioning to the court to gain the certificate titles for the 3 parcel of land, of acres of land. And when we had 4 adverse persons that came up, was Rita Woods and Alvison Edwards, John Wendell Archer, Samuel Spurgeon Archer, Ruby Mae Fox, she was the executive of the estate for Mavilla Archer, Gerald T. Dean estate, and Morrison M. Davis. Now, Morrison Davis and Gerald Dean, they decided not to go through with any of the claim about petition against Roden. Rita Woods noticed that Roden was building on the property, piece of the property that he was trying to claim. But actually, let me go back and say, Roden filed a petition first for 2 pieces of the properties, the 7.713 and the 8.229. However, he came back, that was in 2003. However, he came back and he included the 1.704 acres. So he did the first 2 and then he came back and he got the last one. And he petitioned it to 2 years later. It wasn't until the 2 years that he petitioned it that the others came up, like Archer and Edwards. They came up stating that, yes, this is their property and la, la, la. Now, on the 22nd of May, this is for the Edwards claim ownership. And their claim was on the 22nd of May, 1958. They recorded it in the Bahamas registry. And they said that the property was theirs. It was more of a fight between Edwards and Alverton Edwards with Rita. They fought more with Rowan than any of the other claimants. They said that the land was theirs, and they went to, they felt that he was building in secret on the land without them knowing, without the public knowing. And so they were actually filing for the land. A time unknown to the plaintiff, Rowan, without permission, said build 3 construction on a 0.6, which is a part of the 1 point. I hope I ain't making no sense. He built a construction on that, a part of the 9.10 acres. And that is why Rita was upset, because she said that the land didn't belong to him. Now, where did I go? I had this all down back, you know.
I know you got it down, Pat, because I hear you got it down, Pat. You rehearsed this.
Yeah, so the documents that the Edwards were relying on was the affidavit of Allison Edward, the plan they filed, and the abstract title in which to have show claim for the property. Now, Roden purchased that last 1.7 from Stevenson. And that was the piece he added to after the fact. All right. Then later on, so they had a back and forth with Rita and with the Edwards, which was Rita Woods and Roden. They were back and forth saying that Roden was building on the property. He had structures and he did stuff that they was not aware of. And Roden is saying, okay, no, that's not true. I never did that. And I was farming on it and whatever he was doing on the property. They went back and forth. Everybody settled their property, their claim to the property. I looked at the claims to both property and I saw where Roden, I think, went back from 1758, I think it was. But I didn't see that in Edward's own. But anyway, at the trial, Roden case, he called several witnesses to solidify or to say that he was on the property during the time in question. I think it had to have been, he's saying that he was on the property more than, I think 12 years, but based on the act, he was supposed to be on it 20 years without disturbance or something like that.
Yeah, that would have been the earlier legislation.
Okay, so, all right, but the 12 years is correct that?
Yeah, 12 years is now.
Oh, because in the judgment, she said that he said that he would be incorrect and he did not award him that based on the fact that it was 20 years and not 12. And so that's why he said, okay, he said, it is important to also indicate that the effective date of investigation is 20-year period leading to the date of the filing and not 12 as indicated by Roden. Okay. Anyway, so they had some discussion, and then the Archers came in and said that, oh, they were entitled to all 3 tracts of the land, because initially the Edwards and Rita, those were arguing about the 8.22, I think, and the 7. They weren't, I think, that much concerned about the 1.7 that he had purchased from Stevenson. But they had, they were trying to sell it actually. Rita was trying to sell it, but they could not because Roden put up a fight and he said that he would not let the surveyors, when they came, he would not let them pass to actually go and do what it is that they need to do to survey the land. And so that was a hang up. And then the lawyers got into play where they wrote each other. But what stuck out to me because is the fact that when Rita, those lawyers sent it to Graham Thompson, sent it to Roden's lawyer, he wanted to purchase it. And I'm thinking, if it's already yours, I mean, why would you want to purchase it? Anyway, that was something that stood out to me. And I think that was something that one of the lawyers spoke to. Anyway, they got into that back and forth with trying to settle or make some kind of agreement, but they were refusing to do it. They didn't come to no compromise. The Archers them came in the case late. I think after a while they came in and they were saying that they own all three because their ancestors had lived on it for a while, but that did not materialize too much. They came in, they got some, but it didn't. And so I would tell you now, so that was the gist of the case. Now, the rulings went like this. Okay, so the ruling, the judgment. Okay, so sorry for the papers, it was just so much. Okay, so with the Archers case, okay, the ruling was that Rodens, he awarded Rodens 8.229 acre because she felt like that was what he was entitled to, and the 1.7 that he had asked, that he had purchased from Stevenson was not a legit title because Stevenson didn't even have a legit title to it. So they did not award him that particular part of it. And they only gave him this 8.229 because I think she was comfortable or satisfied that he was, I think it's possessory, he was actually on it and he showed where he cultivated and he did what he needed to do. He actually was there. So she awarded him that. Then out of the other acre, she gave him 0.27 of that. Because she believed that is the only portion that he was entitled to. The Edwards got the balance, what she gave the Archers because of where their homestead was. She gave them 2 acres. And then the balance of the 5.712 acres tract, she gave that to Edwards along with the 1.7 that Stevenson sold to Rodens or gave to Rodens. She awarded that to Edwards. Because some of the witnesses between Edwards and Rodens was a bit shady. He did not was satisfied with it. So yeah, I think that was the gist of what I can.
And the judge said he was very sneaky.
Yeah, he was. He was Edwards, not Roden. That was
Yes.
just doing some bad stuff.
No, he's trying to acquire all of the land without anybody knowing.
Miss Archer, I have a question. For the Rita and Roden case, that's the same one for Westminster and Montague?
No, different case.
Oh, did anybody else get that case? Because I only got the Montague case.
Yeah, I didn't get that one either. That's why I was trying to follow her.
I was
Yeah,
no,
I
I
only got
didn't
the
get
Montague
it either.
case.
I didn't get it either.
Oh, I'm
Oh.
sorry.
Hold on.
No,
Yeah.
I was confused.
Oh,
Yes,
thought
same here.
I was just
thought-
following. I thought the
We were
percentages
still on
for the
Montague.
cases. Yeah, to send to us, but we didn't get that
Oh,
one.
I didn't say something at the beginning.
We were
Yeah,
following what you
because
were saying.
when
Oh.
it started, I said in the matter of all those three adjacent places and yeah, so it's totally different. It's a totally different case.
Yeah.
Oh,
I
yeah.
realized it was a different
realized
one,
that
but
when
I
you-
was thinking
when you
that it
announced the
just didn't
case.
come to me.
Oh,
I thought it was
Okay.
intentional that you didn't send it to us, that you only
No,
wanted to present
no,
it to
remember
Hannah.
I said
have-
everybody must read it?
No.
Hold on 1 second, because I
Yeah.
had,
And you said there's 3 presenters. We didn't get the other one either.
No.
Okay.
only
No,
you,
ma'am.
Ms.
Send it,
Montague,
send it.
No, we
and
didn't.
Ms.
Okay.
Westminster.
I see it right here, where I sent it to the office. Can you send it to them now before we do the third one?
Yeah, because I only got mine too.
Okay.
no, I got that Montague one as well. I got the
Oh.
Montague one. I have the Montague one and I have mine. I don't have the third one.
Well, how you missed the third one?
No, we're missing 2. We're missing the one that Veronique is
I
doing
know
now
the
for
2, yeah. Try sending a message now to see if they have
Is it,
it.
is it possible for you to add another email for me, Ms. Archer?
Hold on.
Because
Uh,
I would have only submitted my work email.
Oh,
Yeah.
okay. Hold on, that's my sheet. Okay, go ahead.
It's my first name, Katora, the letter J
Uh-huh,
at hotmail.com.
okay.
Yes, ma'am. Thank you.
All right, so when I send the cases for next class, I'll put that in.
Thank you.
Okay,
I sent Miss Archer, sorry, this is Michelle
Hmm.
again. I sent you my personal email as well.
okay.
Okay.
Okay, so you'll get the Simon case and then you can read it. But it's a totally different case from
Okay.
Montague.
Okay.
All right, thank you.
So
Thank
we're
you.
reading as it's being presented, or
Repeat that?
are we reading as it's being presented, or do we read it first?
No, you read it first.
Okay,
Yeah. So when I send the cases out for next class, everybody reads it, but the presenter will prepare their summary. And then if you have any questions, you could ask questions. Okay, third presenter. Miller, that's you. Where did she go? Zenobia. She disappeared. How is that possible?
She dropped, probably.
Oh, Lord.
Oh, no. She's on.
Hi, Ms. Archer, I'm here. I sent you a note. Did you see my note?
Okay, let's go do your case. Strawn, Milton, and Daniel and Harcourt.
I sent you a note, Ms. Archer. Did you read my little note?
No. What's your note? When you send this note?
A little while ago.
In the
Can
chat?
I call you? Yeah. Can I call you offline when I get a chance?
Yeah, you can call me right after class.
Okay,
Yeah,
appreciate it. Thanks.
not a problem. So you presenting or not? She go on? Or she come off?
I'm not presenting.
Nice, are you presenting or not?
I'm not presenting. I don't have any materials as yet.
Oh, nothing?
Nothing. But I'll talk to you offline with that.
Okay. So I'll have to reassign Milton for next week. All right. I have another case here called Arawak Holmes and Dennis Dean. And in this one is a dispute between Dennis Dean and Arawak Holmes for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21 pieces of property. So Arawak Holmes is the plaintiff and Dennis Dean is the defendant. So Arawak Holmes is claiming that Mr. Dean was not entitled to enter onto a piece of property, and they wanted an injunction to restrain him from entering onto the piece of land. And they also wanted damages and they wanted cost. Now, Mr. Dean, in his defense, he denied that he entered onto the property wrongfully and that he was wrongfully in possession. So he had a different numbering from Arawak Holmes, but the court said the numbering doesn't matter because when you look on the map, you're talking about one and the same property. So Mr. Dean claimed that he had proprietary beneficial interests in this land. And he said that because he had built 2 duplexes, which he described as being substantial building and improvements. And by reason of Arawak's failure to inform him that they had ownership or papers to the property. Mr. Dean also said that Arawak Holmes was not entitled to benefit by unjust enrichment, meaning that they can't come and take the land with this duplex on it because he has put his money on the land, and that they ought to convey the land to him at a fair market price. So he said that he had bought, when he purchased the land, he had purchased it at a good rate. And he wanted Arawak Holmes to pay him the fair market price. Now, Arawak Holmes said to defend their claim that they are the owners of the land, they asked for their chairman of the board, Franklin Wilson, the director and chairman, Bismarck Coakley, and also the surveyor, Mr. Coakley, and the VP of construction, Mr. Pinder, to give evidence. Mr. Dean said that he would defend himself. So the evidence shows from Arawak Holmes that they had acquired the Pinewood Gardens subdivision in March 1983. And they actually held that property as mortgagor in possession. So their title came from a conveyance in 1942 between Joseph Garfunkel and Amusements Limited. And then in 1956, it moved between Amusements Limited and international agencies. Then in 1957, it moved between international agencies and Alexis Neon and Godfrey Kenneth Kelly. Then a crown grant was given to the McQueens to Alexis Neon. Alexis Neon had a conveyance between himself and Pinewood Gardens Limited. An assignment of the equity of redemption between Pinewood Gardens Limited in liquidation and George Clifford Cullman Arawak Holmes was recorded in the registry. So the court said that it's not disputed that Arawak Holmes has been a developer of land in Pinewood Gardens subdivision since the acquisition in 1983, and that they have sold and continue to sell individual home packages, lots and home packages in the Pinewood subdivision. Now, Mr. Dean claimed that ownership of the subject land by virtue of his conveyance, and his conveyance was dated 1999. And he said he purchased the property from a lady named Mergill Johnson. that McGill Johnson was the widow of Thaddeus Johnson, whose title commenced with a certificate of title granted to him by the Supreme Court in 1985. So now you see you have two people claiming that they own this piece of property in Pinewood Gardens. So the certificate of title that Mr. Dean had, which Thaddeus Johnson claimed was challenged by Arawak Homes in 1985. And in that it was moved to set that certificate by Thaddeus Johnson aside because the court said that it was fraudulent, but the matter was still pending before the court. In the Supreme Court action later in 1985, Judge Sabola had found that the certificate of title that was granted to Thaddeus Johnson was ineffective in law to constitute a good root of title to the land in question. In an action in 1985, it concerned the conveyance dated the 29th of January, 1985, by which Thaddeus Johnson purported to convey Block 119, which comprises the subject land to CB Bahamas Limited. And in that action brought by CB Bahamas Limited against Arawak Homes, the learned judge also found that Arawak Homes was entitled to possession of the land which CBS Bahamas had bought via conveyance from Thaddeus Johnson. So the evidence shows that Thaddeus Johnson also purported to sell the same land he purportedly sold to CBS Bahamas to Mildred Farquharson in 1992. Everybody follow it?
Yeah, I'm following.
Yes,
I have some questions. Go ahead.
The fact then that the certificate of title to Thaddeus Johnson has not been set aside is irrelevant to the decision that the judge had to make. He said it doesn't avail Mr. Dean, who was purportedly sold the same land in 1999. He said the question really is whether Arawak Homes has a better title to the subject land than Mr. Dean.
Miss Archer, can we also get the PDF for this one too, please?
Yeah, I'll scan this one in.
Okay, thank you.
You'll see writing on it, my little scribbles, but you can still read it. So the consul pressed the court to find in the circumstances that Mr. Dean mistakenly believed the land was his. And in his belief, he went onto the lots and built onto the lots at a cost of $300,000 to his detriment. However, Arawak Homes submitted that the only issue for the court to determine was whether or not Mr. Dean had a better title to the land. And if it did, then the matter was finished. Mr. Dean would have been guilty of trespass, and that included the lots on which he had built his duplexes. So I already said that they were going to have these persons give evidence. Now, before I go into the evidence, I'll just summarize, because you can read it in the case, where they followed the case of Ocean Estates Limited versus Pindar. In that case, it said that where questions of title to land arise in the Bahamas, the court is concerned only with the relative strengths of the titles proved by the claimants. The same thing you heard in the Rodin case. It has to do with who has the better title. And that as against a defendant whose entry on the land was made as a trespasser, a plaintiff who can prove any documentary title to the land is entitled to recover possession of the land unless they are debarred by the period of limitation. I am satisfied on the evidence that the plaintiff has the better title to the subject land. Now that was the conclusion in the case of Ocean Estates versus Pinder. Now, in this case, they went even further and they began to say whether or not that justice and equity should be provided to the plaintiff. And in there, they discussed the case of Ramsden versus Dyson. And in it, you read, it says that if a stranger builds on my land, supposing it to be his own, and I, perceiving his mistake, abstain from setting him right and leave him to persevere in his error, a court of equity will not allow me afterwards to assert my title to the land on which he had expended money on the supposition that the land was his own. It considers that when I saw the mistake into which he had fallen, it was my duty to be active and to state my adverse title, and that it would be dishonest in me to remain willfully passive on such an occasion in order afterwards to profit by the mistake which I might have prevented. So he goes on further and he says, but it will be observed that to raise such an equity, two things are required. First, that the person expending the money supposes himself to be building on his own land. And secondly, that the real owner at the time of the expenditure knows that the land belongs to him and not to the person expending the money in the belief that he is the owner. Again, for if a stranger builds on my land, knowing it to be mine, there is no principle of equity, which would prevent my claiming the land with the benefit of all the expenditure made on it. There would be nothing in my conduct, active or passive, making it inequitable in me to assert my legal rights. So then he went on to talk about fraud and the grounds for fraud. So let's go now to the evidence. So like I said, Arawak Homes had Andrew Pinder. He was one of the persons who gave evidence. So Mr. Pinder said, as the site supervisor and quality assurance manager for Arawak Homes in the mid-2000s, he said his duties took him in the area of Pinecone Street in the Pinewood Gardens subdivision. And that while inspecting the buildings under construction there, he observed activity on the land to the east. His evidence was that when he went into that area and observed two foundations were situated in the medium bush, some 6 feet high, he noted there were unsold lots belonging to Arawak Homes in that area. He explained that the activity which drew him to the area was his observation of Mr. Dean's black truck driving to and from that area. He said the two foundations were being worked on at the same time, but neither site had a building permit displayed. Of course, Mr. Dean denied that. He said his sign was up. Mr. Pinder also testified on another occasion that while working in the area of Acacia Street in the said subdivision, he noticed the buildings had progressed. He said one of the lots being developed by Mr. Dean was situated across a road reservation. And he said that even after laying out a foundation and putting up the walls of a building for Arawak Homes, which was near to where he had seen the foundations, the steel was pulled from the foundation and the walls were knocked down by someone, the identity he did not know. Mr. Pinder related in 2002 that he was doused with gasoline as he inspected the building. And he told the court that he ran through the bush and observed one of the structures had his roof on and the other one was up the bell course. He further related that he was confronted about this matter by Mr. Dean on one occasion in Miami. That Mr. Dean, he denied that he had doused him in. He said he did not do that. So what do you think the court decided? Because Mr. Dean said that when he was building the duplexes, no one approached him, no one wrote to him. He said he was aware that Arawak Homes was a developer in the area. He said he
So,
recalled.
Mr. Pinder- Sorry. Sorry, so Mr. Pinder's claim was just verbal?
No, Mr. Pinder works for Arawak Homes.
So, but he never documented any of what he gave us evidence? He
You
never,
mean
like, filed
boss?
anything with the courts, or he never
the police?
presented anything in
Getting-
writing to Mr. Dean?
Or getting doused with gasoline to the police.
No, I don't see nothing here, but no police. And then this one, they didn't give any listing of documents that they presented.
So he filed no reports.
No, well, not according to this.
But I have a question.
Go ahead.
Ms. Archer. My question is that Mr. Dean would have acquired via a certificate from the Thaddeus people, the
Mhm.
Boston people in 1999. And but in 1985, they got their certificate from the Supreme Court.
Mhm.
So the Supreme Court, because Arawak Homes would have purchased their thing in 1983. So the Supreme Court, before making its judgment to grant them the certificate of title in 1985, would that, I don't understand.
But I
Okay.
thought the Supreme Court found that that certificate was not good.
The Supreme Court issued that certificate of ownership to the Johnsons.
Yeah, but then they
And-
found
That is what's
One month-
alleged.
Right,
One
later on, I heard her say they found it fraudulent, right?
Found it to be a
From the
fraudulent
Supreme Court,
document.
oh, it's fraudulent from the Supreme Court, the document itself was just fraudulent, the Supreme Court never issued that.
okay, so listen again. The certificate of title
Mhm.
to which Thaddeus Johnson claim was challenged by Arawak Homes in 1985. And a move was made to set it aside on the ground of fraud. But that matter was still pending. Now, in another matter in 1985, the judge found that the certificate of title granted to Thaddeus Johnson was ineffective in law to constitute a good root title to the land in question.
Yeah, I get that part about it
Right.
constituting a good root title because they got the trace title back for so many years. Yeah,
So that same one now, where the judge said that the certificate of title to Thaddeus was ineffective,
right.
that concerned the conveyance dated back to the 29th of January, 1985, where Thaddeus purported to convey a block of land to CBS
So he
Bahamas.
knew- So he knew that the property wasn't his
Yes,
and still went ahead and built.
yes, no,
No,
yes.
No, not Jane. Thaddeus
No.
still went ahead and sold.
He
Thaddeus
sold.
sold it to
Sold this
He had
property to
no title.
CBS.
Oh, wow.
It sounded like Thaddeus sold it a couple of times, a couple of different people, eh?
Yes, he
Several
did.
times He sold the same property.
He
Right.
sold to the CBS Bahamas, and then he sold it to Mildred Farquharson. Then he's selling it.
Exactly.
Yeah.
Right, so he was acting fraudulently all along, but Mr.
With all
Dean
of
thought
them.
he had good title and
But-
was acting in good faith when he started building.
But I could see Mr. Dane claim if Arawak knew that that property was theirs and said absolutely nothing to him and they see him building.
Well, the man, Mr. Pinder, said that he spoke to him and he tried to throw gasoline on him. But Mr. Dean said that didn't happen.
So you
Right,
say,
so
and I
why
could
they
see
never
Melissa's,
reported to
I could see
Arawak Homes?
Melissa's, right, I could see Melissa's question if they ever, at least guess and
Put something
evidence,
in-
say something in
No,
writing. Yeah.
Right, knowing that how big the company is, Arawak, I can't see them waiting so long until the building was completed before they question it. Why didn't they?
Or even
go
bring
and-
him to
and put
court.
some, right, take
Mhm.
him to court during the initial stages and to have an injunction done when it was still just cleared on the property, when he just was doing the foundation and everything. Why did they wait until the building was so far along and he had invested $300,000 of his own money?
And
Yeah,
the thing
That
is,
sounds
I
sketchy.
could see why they would wait, because they know that they had the title. And they
Right,
had
so but in them waiting,
principle of
Absolutely
equity.
correct.
something that Miss Archer read when she said that they were saying
Principle of
that
equity.
if they, exactly, if they
Mhm.
knew full well what was going on and they failed to say anything and they let it progress, well, then they should, the court should rule against them.
Well, they said it, but they waited, and because I feel, I mean, I know in the nature, I so
Court should make them pay it.
I
I
feel,
know.
knowing the
Let him build
nature,
it.
he told
And
him,
then
and they
Make
say,
them
let
pay
him build
for the
that, and that can be
value.
mine.
No, the court should make them pay the value of the building
Court said, but
and property.
Isn't
Okay,
that something
okay,
that Ms.
let
Archer
me
read
carry on.
with reference to
Too
that?
excited now.
huh?
Y'all getting too excited.
I mean it,
So-
man, because I ain't fair.
So Mr. Dan testified that in 1999, he was approached to purchase the subject land by Neville Johnson, the son of Thaddeus Johnson, and paid the purchase price of $30,000. He said he purchased 20 lots, 100 by 25, which translated into 10 lots, 50 by 100, and sold 2 of the lots. He said he began building his duplexes on the land in 2001, which took him a year or so to complete. He also testified that during the building of the duplexes, no one approached him, nor did anyone write him about his building. He said he was aware that Arawak was a developer in the area. He recalled seeing Mr. Pinder on one occasion and said they exchanged words, during which he said Mr. Pinder told him someone had thrown gasoline on him. Mr. Dean told the court that he laughed and told him it was strange that he would put his life at risk for Arawak Homes. He told the court in his evidence in chief that Arawak Homes did not issue a writ against him in 2002. So on cross-examination, he admitted he was arrested in January 2003, allegedly for trespassing on that same land. He denied he was served an injunction, but he explained that he was shown a document he was never allowed to read. He testified that on his arrest, he had completed both buildings, and he admitted going before a judge in the Supreme Court and appearing before the Court of Appeal, and acknowledged that the Court of Appeal ordered him not to do any further building on the land. Mr. Dane maintained that the first building was finished in January 2002, and the second was completed in July 2002. He also said that his building permits were displayed on the buildings. Because remember, Mr. Pinder said he didn't see any permits on the building. And he denied he knew that Thaddeus Johnson purported to sell the same land to CB Bahamas. And he denied he knew at the time of the conveyance that the court found the certificate of title of Thaddeus Johnson invalid. He testified that he only discovered these matters after the action was commenced against him. And he referred to his affidavit and supplemental affidavit that he swore in March and May 2003. He said, however, that notwithstanding that he found out that Thaddeus Johnson had purported to sell the land to CB Bahamas, that had no effect on his mind about the ownership of the subject land, because the documents was not the same property. So Mr. Dane also claimed that he was shown the land before he purchased it, and that he saw the stakes delineating the property on the ground and in accordance with the Nassau Village Plan. He said he instructed his lawyer to represent him on the purchase. He told the court that he did not obtain an occupancy certificate for the first building on completion, but sometime later. And when he was shown the occupancy certificate in March 2003, he said that was for the second building, which he had completed in July 2002. He told the court that the certificate does not show that he worked on the building up to the date of the certificate, and is not evidence that he was building up to that time. He said he didn't procure the certificate until some 10 months after the building was completed. So Mr. Dean admitted that he knew Arawak Home was building nearby. He admitted that he moved the blocks from the side of the foundation built by Arawak Homes in Pinecone, but said he did not interfere with the foundation. He said later that he thought he had a right to knock down the building, which was going to block his access to his buildings. He also admitted that his only legal right to the land was through possession, but did not explain how it was that he was now claiming a documentary title through the certificate of title granted to Thaddeus Johnson. He admitted that he knew of a number of court actions between other persons and Arawak Homes in respect of land in that same area. And he also knew that Arawak Homes had recovered all of the land. So when he was shown the conveyance between Thaddeus Johnson and Mildred Farquharson, dated in 1992, he accepted that the land purported to be conveyed by that conveyance was the same land that he bought in 1999. And then he denied, of course, throwing the gasoline on Mr. Pinder. So Mr. Dean maintained throughout the hearing that he believed he owned the land and did not hide the construction of the building on that land. So let's see what the judge says. The judge says, Section 52 of the Conveyancing and Law of Property Act provides that a purchaser shall not be prejudicially affected by notice of any instrument, fact, or thing unless it is within his knowledge or would have come to his knowledge if such inquiries and inspections had been made as ought necessarily to have been made by him. So in order to get a good and marketable title, such title must begin with a root at least 30 years old, and the risk is on the purchaser, who must satisfy himself by a full investigation of the title before completing the purchase. It goes without saying that a bona fide purchaser who is giving value for his title would reasonably be expected to investigate the title by doing the usual and proper inquiries before paying for it. Had this been done, Mr. Dean or any legal counsel working on his behalf would have discovered the conveyancing and court orders affecting the subject land and would know that the vendor could not pass legal title to the subject land in 1999. Any comments?
I agree. I agree. I wondered if he ever had the title search done on the property.
Well, he was defending himself.
But
Ms. Archer, did you say that he had a lawyer at any point in time?
No, he said he had a lawyer. He said he got a lawyer for something. What was that?
But it wasn't a title search.
No, it wasn't a title search.
Okay.
I think you said he told his lawyer to proceed with purchasing the property, so you think that the lawyer would have done a title search.
A title search.
But I know firsthand that these lawyers many times don't do what they're supposed to do. So it's unfortunate that the customer, you know, his client didn't know
Probably
what was expected.
Sales agreement. He probably just
Okay.
read the sales agreement. That was it.
Yeah.
yeah. So,
So-
he what the
Okay.
sorry.
No, go ahead.
He then I mean and he must have gotten a lawyer to do the conveyance to his property, or he just
The seller probably,
huh?
Thaddeus' wife probably had her lawyer draw it up.
I guess.
And that's why many times,
Itself.
well, see, that's why many times we tell them a lot, you know, they would be like, oh, we can save money by
Independent.
sharing the same attorney. And and I always advise them against that. Get your own attorney, because a lawyer can't represent both interests.
Don't worry, we have a juicy case coming to that later down.
They can.
They can, but that's your risk.
No, they can, but should they? Because like in the same
They can,
instance
they
here,
can. it can eventually cause some conflict of interest.
Exactly, right.
Yes.
But Ms. Archer, I have a question because you started to read something else where you were saying that there was you read off something with reference to if the person who owns the property sees someone else building on their property. I thought you were headed in a different direction with the ruling when you read that.
No. Don't forget now, when you, as you read more of these cases, you'll begin to see the judge has to settle what the law is.
Oh, okay.
He has to settle what the law states. And then he looks at the evidence that is given. And then he's going to come, okay, so I told you all what the law was.
Mhm.
Now this is the judge. After he's heard all the evidence, read all the affidavits, he's now coming to his conclusion as to whether or not Arawak Home should get this property.
Ms. Archer, sorry, before you move on, my concern, if I heard you correctly, the same Mr. Dean, in turn, he got 20 pieces of property from these studies people,
Mm-hmm.
and he sold 2.
Yep.
That's deep. All right.
Mm-hmm. He did. So the judge says that based upon what I just said, that Mr. Dean had constructive notice of the state of the title of the land when he purportedly bought the land in 1999. So he said, having heard Mr. Dean's evidence on observing his demeanor, I do not believe he held any mistaken belief that he owned the subject land. In fact, I find that he knew he did not own the land when he took possession. So the judge not only look at what you say and what you write, but they also look at your demeanor, how you act. He say, for one thing, Mr. Dean indicates in his affidavit that in 2003, he found that Thaddeus Johnson had sold a property he had bought to someone else. Yet, he gave evidence in his trial and was adamant that he owned the land by virtue of the 1999 conveyance. That affects his credibility with me. Second, I accept the evidence of Mr. Pinder and Bismarck Coakley. And I believe Mr. Dean attempted to hide the construction of the duplexes by maintaining the height of the bush. Remember I told you all the bush was the same height as the building?
Yes.
Mhm.
And by failing to display the building permits on the site as required by law. Because Pinder say he saw no permits, Dean say the permits were there. I find this together with his evidence of his response when Pinder told him about being doused with gasoline. And his admission that he moved blocks from a foundation being constructed by the plaintiff indicate a consciousness of the fact that the subject land was not owned by him. Third, the judge say, I reject Mr. Dean's evidence that he built both duplexes in 1 year. The judge say, I believe the evidence of Mr. Pinder and Bismarck Coakley that the buildings were not completed when they observed them in 2002. I find that evidence consistent with the second building being completed near to the date of the occupancy certificate. And I do not accept the explanation from Mr. Dean that he waited 10 months after the completion of the building before obtaining the certificate. 4, Mr. Dean admitted he knew Arawak Homes was the developer of the subdivision. Just by Arawak Homes against person claiming possession of the land in the same area where he was. And he said, I find this continuing to build with this knowledge, and the lack of any effort on his part to clarify his entitlement to the land before expending further funds in building on the land. It also shows consciousness of the fact that the land on which he was building did not belong to him. 5th, I don't believe Mr. Dean when he said he was shown stakes delineating the land he proposed to buy, and that the stakes were reflected on the Nassau Village Plan. The judge say in the Supreme Court action in 1985, that plan was said to be of a paper subdivision and did not represent the reality on the ground in the Pinewood Gardens subdivision. He said Mr. Coakley's evidence confirms that position and shows that the land had been subdivided in accordance with Pinewood Gardens subdivision plan. In the premises, it was not possible for Mr. Dean to have identified stakes with reference to the Nassau Village Plan. 6, I find that Mr. Dean therefore deliberately tailored his evidence and lied when he said he was sold 20 lots of 100 by 25 and that he converted them into 10 lots 100 by 50. This was for the purpose of conforming this evidence to his evidence that he saw stakes on the ground and delineated on the Nassau Village Plan. The judge said, I am satisfied that it would not be unconscionable or unjust for Arawak Homes to assert its legal right to possession of the lots on which the duplexes are built. And I find that Mr. Dean is entitled to recover the same. With regard to Mr. Dean's claim, and I find that the Arawak Homes is entitled to recover the same. With regard to Mr. Dean's claim that he ought to be paid the value of the land with the duplexes, I find Mr. Dean has no equity to satisfy the recovery of the sum expended, could not therefore be awarded. As Lord Cranshaw said in Ramsden versus Dyson, to which I referred above, there is no principle of equity which would prevent such a plaintiff in these circumstances from claiming the land with the benefit of all the expenditures on it. Arawak Home contends in its demand for damages, in addition to the recovery of the land, that because of the unlawful actions of Mr. Dean, it lost the ability to develop the subject land and earn money from the sale of lots and home packages. Mr. Go ahead, hold on. Now we're finished, then we can go talk about it. The Dean's estimate of the loss, Arawak Home's estimate of its loss is 900,000. Counsel for Mr. Dean answered that this claim is speculative and there is no evidence to support such loss and the amount claimed. So the judge said, I have pressed alternatively by Mr. Dean to deduct from any damages I may find recoverable by Arawak Homes the sum he expended on the duplexes. As I have said, he has no equity to satisfy and cannot recover that sum. Indeed, the evidence is that the lots on which the duplexes were built were zoned as single-family lots, and further, that one of the duplexes encroaches on the road reservation, and both duplexes must be taken down at a cost to Arawak Homes. So in the premises, I accede to Arawak's own claim and award damages for any loss incurred during the period it was dispossessed by Mr. Dean. And if none, a reasonable remuneration for the use of the land by Mr. Dean. In the circumstances, I dismiss Mr. Dean's counterclaim and grant relief to Arawak Homes. A declaration that Mr. Dean is not entitled to enter the subject land. Possession of the subject land was given to Arawak Homes. An injunction restraining Mr. Dean and his agents or anyone else who worked for him from entering the property. He had to pay damages and he had to pay Arawak Homes legal fees. And that case was done by Senior Justice Anita Allen. Comments?
Wow.
Can
So
we
he
get
lost his
Can we get a
duplex.
copy of that, please?
Lost- sorry.
Yes, I'm going to send this one to you. I put it on the side right now.
He lost his duplex.
So he
Plus-
lost
Yes.
everything.
Plus,
The
he had to
duplexes,
pay.
right?
And he ended up with
Mhm.
additional cost.
Plus he had to pay our homes.
Mhm.
My lord,
900,000 plus
no, he had to pay them for.
for
Well,
them not being able to develop the property because he
Did they take the
encroached on
property
it.
number?
child, I wonder if he burned that down.
That's
But
interesting. Joy.
the thing about it is I felt sorry for him initially as it progressed until you heard the full story and the fact that he most likely knew what was happening. But of all the people to play with, why did he think Frankie Wilson of Arawak Homes was the one?
Someone
That was his
to-
biggest mistake.
Yeah, he went
But
in
why
with.
didn't, why didn't they take legal action sooner?
You didn't
Why
have
they
to.
did it?
Well, and I tell you why, Frankie know he had a winning case, so he said, let him bill it. I got
Yeah,
this.
let's do this.
Let him bill it.
I just want to know the property number.
And that,
That's
So
why
what
you
that
want
happened
the
to
land,
the
case,
other
eh?
that
properties?
land,
Marissa,
the
that's why
land
you
was
want
in
to
zone
do
for
the case.
multifamily.
I wonder what happened to the other properties.
It would be the same thing. All those matters would be in court because people either would have built on it or purchased it from Thaddeus Johnson, and
Mhm.
it was a fraud. So they would end up losing their money because you see, he was deceased, and his wife was now selling the properties.
So now I wonder
Yeah,
if
the
Frankie going
losses.
straight through for everything and find out if people own properties who would build houses and things, if now he would have placed before the courts an injunction with them.
Yes, he probably did.
So I'd
No.
like to see the case with the church.
Oh, yeah.
Hey, I thought first when
I
I
really
when I
like to
first
read
saw
that.
the when I first read my case, I thought that was a Frankie Wilson thing. So I was like, I know this case, but that wasn't it.
Now you see how interesting it is. Now everything that we read in last class, you see how when you read the case, it makes it practical.
Yes.
Yes.
Yes,
Okay, so when you
Yes.
talk getting a root title, you see what's involved. When someone comes to purchase a piece of land, or they're getting a mortgage and the document goes to the lawyer, by everything weighs on whether or not that lawyer has that knowledge and that skill to make sure that that property has a good title.
But
That's what I'm
even-
wondering about right now because I'm trying to figure out if every one of those lots, not a one of them had an attorney who did a root title search and prevented them from going down that same road. That's sad.
Yeah,
Obviously, because then that man sold it to some other people and they ain't come up to say nothing. Or they don't know.
they probably don't know.
So
So-
too,
They take advantage of people's ignorance. A lot of people just don't know any better.
yeah. And then
So-
sometimes too, I see lawyers who aren't real property lawyers, I call it, but because they're lawyers, they could just go on and draft up some stuff.
Well,
That's how I
imagine.
feel. They just say because they're lawyers, they know what they're doing.
You have to choose your attorneys wisely.
So in
Right.
this
Yeah.
case,
So
in this
imagine
case,
there are
Mr.
probably still persons holding on properties, thinking that their title is good, and they may want to pass them on to their kids and stuff, only to find out that those titles are not good.
But Ms.
Exactly.
Johnson, how about some bringing property property papers into the bank? I ain't even record it.
No,
That's a
ma'am.
travesty.
I had
Say
it for
what?
years, holding on it for years. I said, it's just like a piece of tissue paper. You need to go find a lawyer and get this
So that
recorded.
ain't no good. That ain't no good title.
That ain't no
So in
paper.
this case, if Mr. Dean had a lawyer conduct a title search, he could sue that lawyer.
But I don't think he requested a title search. Doesn't appear to be that he requested that. No.
Mhm.
Lawyer.
Seems
but
like it might have been
listen,
intentional because the judge feels as though he knew that it was a fraudulent
Yeah.
transaction. So maybe it was intentional that he didn't ask for a title search.
But if the lawyer drew up the conveyance, normally they would give you the clear and marketable title to to the property. So that lawyer.
Only if you're getting
like she said,
financing.
No, it's the vendor's lawyer. No.
No,
And
I'm
just
saying,
Go ahead.
if when a lawyer draws up a conveyance and would have sworn to all of this, in order to have that conveyance recorded, would he not have, well, he may not have carried out the title search, but isn't he liable for drawing up that conveyance? Ms. Archer?
I'm thinking. I mean,
I mean, is he liable for giving a good and
But-
marketable title based
No,
on his? search?
Liable to say this man get right ownership
yeah, but the point is that lawyers work on instructions.
on instructions for a conveyance?
It's no, I'm saying it may not have been his lawyer who did the conveyance. I'm thinking it probably was Thaddeus' lawyer who drafted the conveyance. It had to have been Thaddeus' lawyer. Because otherwise that would have come out in this case. No mention was made of the lawyer who prepared the documents on Mr. Dean's side.
Right.
It may be in the Thaddeus matter, we may find that out.
So too, Ms. Archer, I was just thinking too, because sometimes too, we have people who come and just say that they purchased their property cash, and then they want to, because the property was never mortgaged, and then they come and they want to now mortgage this property. And when we send them to the lawyers to do their to-do and tell them that they need to bring in, title documents. Where's your title documents? Oh, I don't need that. I have my conveyance. So this may be like that in this case too as well. That Mr. Smart Man who want to represent himself against Arawak Homes. Too smart.
Uh-huh.
He should have known better.
He outsmarted himself.
He
Yeah.
also himself, because he saw Mr. Pender there. He knew what he was doing. If I bought property from you, right?
Mhm.
Thoughts, I'm going to build. Why would you leave the trees to grow up around it while you building? Aren't you trying to hide? That's the
Yep.
same thing.
That's
That's
how
it.
the judge felt.
Yep.
That's
what
true.
Roden did.
Mr. Simon Roden did the same thing.
Yeah, he did the same thing.
You try to hide it, and you hide it so that whoever's the rightful owner cannot stop it.
Yep,
Hey, you're doing on my land.
yeah.
Deep.
It is deep. And I'll give you some more fascinating cases to read. Any more grumbling now? Everybody is eager to get a case. Everybody can't wait. Everybody can't wait. What case it could be this time? Who will she pick? Don't worry about it. More cases coming. All right. So unit 2 is about the whole conveyancing process. And that's a good way to segue into that after we've read about Arawak Homes and Mr. Dean. So there is a process. We know the first thing is the agreement for sale. An agreement for sale sets out the terms and condition for the property, gives you the price, what's the deposit, when the contract should be finished, and the vendor and the seller's obligation. And we know the key thing about the agreement for sale is making sure that you have good and marketable title. That's the key. Good and marketable title. Mr. Dean, no, he didn't have one. But he still went ahead. And then, like you said, he thought he could battle with the big bad wolf. But he didn't have a leg to stand on. So the deposit is normally 10%. And then the vendor has to adduce the title. He has to provide copies of what he possesses to show that he has good title. And it's up to the purchaser's lawyer then to go through that abstract to ensure that there is a good and marketable title. So the purchaser of land is not required, is not entitled to require title to be deduced for a period of more than 30 years. So you go back 30 years, or you go back to a period that it doesn't extend further than a grant or a lease by the crown. Or if there is a certificate of title by the court. So there's three things you're looking for when you look at an abstract of title. How far back do I go to get a good and marketable title? Now, we all know that people can have a certificate of title from the crown, and that also can be fraudulent. Because if it's based on fraud, it's not until the fraud is actually being determined that someone knows that it is fraudulent. So the purchaser's attorney investigates any outstanding real property taxes, any association fees if it's a condo, any utilities that need to be paid, and if it has to do with a property for investment purposes, that means that you also have to seek the requisite approvals from the investment board. Now, the purchase attorney can see where there are issues in the title, abstract of title, and they can raise requisitions. So in those requisitions is where they would be called, they see defects in the title. And they can ask the vendor to provide answers to the questions that they're raising, because it impacts the title. The agreement for sale normally provides for a specified time period for requisitions on title to be made by the purchaser's attorney. The purchaser's attorney can also raise questions on government approvals, on subdivisions. You heard I think it was in the last quarter of last year, that landmark case on subdivisions. Yes, no? No one?
I didn't hear about it. No. I don't recall.
Oh, so you'll recall when I give it to you to read.
Okay.
Yeah. Subdivisions. Outstanding real property taxes and utilities. And you know, the government is now pressing for real property tax, because that tax is the first thing that comes out. And like everything else, Bahamians do not like to pay real property tax.
Well, I know here in Freeport, Port Authority on top of that.
Yeah, well, the government is now getting the same way on top of that. So anything that you want to do and it involves dealing with government, that's the first thing they're looking to see if you've paid your taxes. If you haven't paid your taxes, nothing is happening. So once the requisites on title are satisfactory, the purchaser's attorney will prepare a report or an opinion on title for the purchaser or for the bank. The draft conveyance of the property is prepared by the vendor's attorney and is also reviewed at the time when you're doing the requisitioning, and the title and the cost list searches by the purchaser's attorney. So like we were saying, if Mr. Dean had an attorney, the attorney would have checked the cost list for the Supreme Court and the Court of Appeals, and he would have seen that there was a matter before the court. But of course, he probably wanted to do it all himself. And that comes at a price. So once appropriately amended and approved, the conveyance is finalized by the vendor's attorney and is executed by the vendor and the purchaser. The completion statement is prepared by the vendor's attorney, and the balance of the purchase price is paid, less of course, stamp duty, apportionment for rates, real property assessments, utilities, and whatever else is applicable. The vendor's attorney may forward the title documents to the purchaser's attorney in escrow pending the final payment. The legal fees normally range from 1.5% to 2.5%, and that's paid on or before the completion of the vendor and purchaser to their individual attorneys. Commission to real estate agents are also paid at this time. Requests are made to utility companies to return deposits to the vendor, and all utilities and real property tax assessments are placed in the purchaser's name. Once the balance of the purchaser's price is paid to the vendor's attorney, subject of course to the completion statement, and the vendor attorney acknowledges receipt of payment, the property transaction is complete. The conveyance is sent for stamping at the public treasury, and the stamp duty is paid on the conveyance, which is normally split between the vendor and the purchaser, and is based on the total consideration price of the property. Now we know when property is being purchased by non-Bahamians, they normally purchase property via an instrument, an IBC, that is normally used for investment holdings. So by putting your property within the
Oh.
IBC, go ahead.
Sorry, can you repeat that for me, please?
Non-Bahamians, when they purchase property in the Bahamas, they will incorporate an IBC, an international business company, which is more flexible than a company that is incorporated under the Companies Act. That company that they form is a holding company, and that's where they hold their assets, the property in the Bahamas. So non-Bahamians are acquired under the International Persons Landholding Act to register their properties with the Bahamas Investment Authority. And they do that by obtaining a certificate of registration. Other than that, they require a permit from the investment board prior to their purchase. A certificate of registration is only required for vacant and is not only required for vacant and non-vacant property, but is also for condominiums or any property under 2 acres that will be used as owner-occupied property. A permit is required by non-Bahamian property owners for the purpose of property that is for 2 or more contiguous acres, whether it's to rent or a portion of the property, or where the property will be used for commercial purposes. Non-Bahamians also have to obtain a permit for any subsequent purchase of property. So normally when foreigners purchase land, that is a long process because they have to wait for approval from the government. And you'll see when we come further down in the chapters, when they are doing things like building hotels and resorts, with the passing of the most recent legislation, the environmental impact assessments have to be done, and notices have to be put in the newspapers, and public hearings have to be held. And all of that, of course, is due to climate change. Permanent residents are required to register their purchase of real property, whether vacant or non-vacant, but they are not required to obtain a permit. It noted that non-Bahamian lender that acquires property or security on properties in the Bahamas, they are required to obtain exchange control approval and also a permit from the Bahamas Investment Authority. So the Bahamas recently, very recently, updated its legislation on real property tax. They also updated their legislation on VAT, and they also updated their legislation on the Stamp Act. Everyone aware of that?
No, I'm
Yeah.
not.
Yes.
Yes,
For the
I
most
know,
part,
the
yes.
property tax thing.
Yes. So under Real Property Tax Amendment 2022, what the government has done is has changed or amended the definition of properties. And remember, all of this is in focus in terms of the government being able to obtain its taxes in order to pay its monthly expenses. So they say commercial property is any property used for business purposes including property that falls within the proviso of the definition of residential property. And residential property is any property that is not owner occupied, comprises not more than 4 units, is beneficially owned by a Bahamian or a person registered under the VAC Act for the operation of a property as a commercial rental establishment, and is used solely as a dwelling place. So if a person owns more than 4 dwellings that are not owner occupied, each property could be classified as a commercial property. Unimproved property means any property on which no improvements have been made. And this includes properties under construction unless it is occupied or a certificate of occupancy has been issued. It doesn't include properties used to carry on businesses. So let's look at what they said in the stamp amendment to the Stamp Act. It says that if you're transferring land that has been removed from the legislation, and where a transaction comprising the sale of any business involves a transfer of land or share in a landholding company, that transaction will be subject to VAT. Because remember, one of the issues they had was people were paying stamp duty and paying VAT. Leases of realty with a term of less than 5 years are subject to stamp duty at 2.5% of the annual rent. And of course, they've carved out instruments that are now exempt from stamp duty. The lease of a realty with a term of 5 years or more, no stamp duty. Transfer of a crown lease, no stamp duty. Affidavits or affidavits of loss relating to conveyances on which the stamp duty of VAT was never paid, no stamp duty. Any agreement that is not listed in the first schedule of the Stamp Act, no stamp duty. Declaration of condominium, right of the grant of right of way, a lease of easement, and renunciation or release of dower, there is no stamp duty. So in instances where there is a transfer of mortgage, the instrument evidencing the satisfaction of the subsisting mortgage and creation of a new mortgage is exempt from the payment of stamp duty. Under the Stamp First Home Exemption Act 2016, the treasurer may stamp an application for the exemption of stamp duty on an instrument made pursuant to the provision of the Stamp Amendment Act 2002 and the Stamp Amendment Act 2008, where approval for the exemption had been previously granted and where the title document to which the application refers remains unstamped. So where a loan has been repaid on a mortgage property, but the satisfaction of mortgage has not been stamped in accordance with the VAT Act, the mortgage property shall still be deemed to be under a deed of mortgage. And the mortgagee will be liable to pay the real property taxes on commercial property if taxes remain unpaid in excess of 90 days. So there have also been an amendment to VAT. And it's long. So what they've done is they've given you new rates now for the supply of real property. A deed of conveyance, an assignment or transfer of real property, the applicable rate is 10%. Every deed or conveyance, assignment or transfer of real property to an individual, they have it in gradual amounts. 2.5% if the value does not exceed 100,000, 4% between 100 and 300,000, 6% between 300 and 500,000, 8% between 500,000 and 700,000, and 9% between 700,000 and 1 million, and 10% where the value exceeds 1 million. For those with a first home as a Bahamian, is 4% where the value exceeds 300,000 but does not exceed 500,000. And if you have a long-term lease, it's 2.5% VAT you have to pay where the value doesn't exceed 100,000. And anything over 100,000, you have to pay 10%. So a mortgage or transfer of mortgage of real property is 1% of the amount of the mortgage or transfer of mortgage amount. If you reconvey a real property to a borrower or mortgagor, is 0.10% of the mortgage amount. An endorsement or mortgage under Section 32 of the Act is 0.10%. So the government means to collect its funds. So the other pages just give you a summary that I just gave you just a highlight of it. But the other pages just give you all the detail of what's required and change under the real property tax and the Stamp Act and VAT. Now, properties that are owned by religious institutions, trade unions, civic organizations, and nonprofit organizations and burial societies are exempt from real property taxes. The normal appraisal fee for appraisers is $350 to $500. That hasn't increased, eh? I know after COVID, everything is going up.
They normally charge based on the size of the building, but that's the average cost.
That's average, okay. Title search is $350 plus VAT. Recording fees is $450 per page. And for mortgages, so bank service fee may vary. Legal fees is 2.5%. And of course, fees can be negotiated. Now, leases. Everybody understand when you say a contractual agreement, everybody understand what is a contractual agreement in law?
Yes.
All right. So a lease is a contractual agreement between the landlord and the tenant. And what the lease does is outlines the duration and the obligations on both the landlord and the tenant. It gives you the rental amount, and it also gives you your restrictions. So you have duties, you have restrictions, you have responsibilities, you have rights, you have obligations. So a lease could be for a short time or for a long period. And there are certain characteristics that must exist for a lease to be considered a valid lease. So what are those essential characteristics? The tenant must have the right to exclusive possession of the premises. And that's, of course, is subject to the lease. So if the person granting the lease remains in general control of the property, then there is no tenancy. So that's why when you have a lease, for your landlord to come onto your property, they have to inform you. They can't just take their master key and open up your place and go and look around and see whether or not you're keeping the place tidy or not. If there is no defined premises for the lease, only a contractual obligation to provide storage for goods with no defined space, this arrangement will be considered a mere license and not a tenancy. So even though, see, you can enter in an agreement for a lease, But when you go before the court looks to determine whether or not you have an actual lease or whether you're just occupying a space. A lease can't be for an uncertain period. The period has to be determined. And the lease has to be created in the proper way, which means it follows all the legal formalities. So there are types of commercial leases. A lease can be for a fixed period of certain duration, short or long. A yearly tenancy goes from year to year until it's terminated. And that's either by the death of the landlord or the tenant or the assignment of interest. And you see this a lot with people who have long-term properties like in New York, when they have those homes that they actually lease and they stay in it until death. So generally a yearly tenancy may be created by implication in instances where a person occupies premises with the owner's consent. And in those instances, the tenancy was intended and the rent charged or measured for a year is paid and accepted. Monthly, weekly, or other periodic tenancies may also be created in the same way as yearly tenancies. And it either can be an express agreement or it can be by inference. So if your landlord comes to collect every week or every 2 weeks, even though in the contract it is not written of the frequency for payment, just by the actions of coming to collect the rent and you paying every 2 weeks or every week, then it is said that by your action, it is inferred that that is the period for payment. A tenancy at will, and that is where a tenant, with the consent of the landlord, occupies premises as a tenant on terms that either party may terminate the tenancy at any time. So unless parties on the tenancy at will agree with the tenancy, if on the tenancy at will agree that the tenancy will be rent-free, the landlord is entitled to some compensation to use and occupy the premises. A tenancy at will terminates when either the landlord or the tenant does any act that is incongruent with the continuance of the tenancy. That is, either party gives notice to terminate the tenancy. But we also have commercial leases. So in addition to the party's premises rent and duration, a commercial lease should specify, again, the rights to duties, responsibilities, and obligations of the landlord and tenant. And in some instances, you have subtenants. And they agree to be bound by the usual covenants. The parties to a lease should ensure that certain provisions for repairs, insurances, indemnifications, notices, the options to renew, even in terms of options for subtenants and the requirement for subtenants, all that should be laid out in the lease. In the absence of any express terms and conditions of the usual covenants, there are implied covenants for quiet enjoyment. And that allows the tenant to recover damages from the landlord if the person to whom the covenant extends physically and substantially interfere with the tenant's enjoyment of the demised premises. So once you lease a property, you should have exclusive possession. And exclusive possession means that you enjoy the premises free from interference from the landlord. So in addition to the implied covenant of quiet enjoyment, a landlord has an obligation not to derogate from his grant to the demised premises. In some instances, he ensures that certain premises are fit and in good repair. The tenant has an obligation to pay rent, rates, and assessment, not to commit waste, and to allow the landlord to view the premises to make repairs. in the absence of the express terms and conditions. Now, there are, in some leases, you see where the landlord will put a clause that if any repairs are to be done up to a certain limit, that the tenant should pay that. And then only for larger sums will the landlord actually pay for those expenses. Any questions?
No, ma'am.
Y'all sound like y'all getting sleepy now. Y'all like cases. They keep you all awake.
Yeah, we Bahamians, we don't like reading.
Yeah, I know. All right, so next week, let me see this. I think the next chapter is short. Yes, the next chapter is not that long. So I may send about 5 cases. How that sounds?
Sounds
It
good.
sounds good.
That's good.
All right,
Send that onto my case. That sounds good.
that sound good?
5 hours?
Yes, I'm gonna send some more. And so once I send those out, then you have opportunity to read and present. Okay? Everybody must read, but just the presenters, and then you can ask questions to presenters. Okay?
And don't forget to send us the missing ones from today, please.
No, I wrote that down already. I have that. I got that.
You know, we like people business.
Yes, but I'll send it to you. I'll send the 4 in 1. I'll send it. Okay?
Yes, ma'am.
All right. So have a good evening. Be prepared to read. No excuses.
Okay, good evening, everyone.
Okay, good evening.
Thank you. Good evening. Oh, golly.